We are rolling from Nobel Peace Prize winner Maria Ressa and Marty Barron coming. I'm so appreciative they were able to make it. Marty's literally flying back to the airport now. Just give him one more round of applause. Thank you. So our next guest will appear remotely, which we rarely do at the DCN Summit. Sarah, come on out. Sarah Fisher will be interviewing. It's worth it to have her point of view from the front lines of the fight against the abuse of monopoly power. She's taken on both big tech and biotech. When you seek to hold powerful monopolies accountable, as she's been doing for years, starting with her influential 2017 Yale Law Journal article, Amazon's Antitrust Paradox, it's hard to get a lot of love, and the critics rise up. But those who claim that she's had a rough time are flat out wrong. She's making a generational impact, energizing the antitrust field, and fighting for greater consumer protection. Please welcome virtually to the stage F.T.C. Chair Lina Khan in conversation with Sarah Fisher of Axios.
Hi, Lina, can you see me?
Yes, hello, good morning.
Good morning, thank you for doing this. We appreciate it.
Great to be here. Apologies, I can't be there in person.
No worries, we're grateful for your time. Wanted to start off with news of the day. Obviously, you have opened up an investigation into big tech companies like Microsoft, Amazon, Google, and their investments into some of these newer AI companies like OpenAI and Anthropic. Want to understand, what are you looking for in particular that you think would present some sort of competitive or consumer harm in those relationships?
So this inquiry in particular is scrutinizing the relationship between some of these large technology incumbents and the newer AI firms that they've been doing massive investments in, and looking under the hood to understand, what are the strings attached effectively? Are there certain expectations of exclusivity? Are there certain rights to board seats or other mechanisms to be influencing business strategy or the direction of innovation? And just stepping back, there are a couple of reasons why we're doing this. One is, historically, we've seen that these technological inflection points, these moments where you have potential paradigm shifts in the technologies that are available, can be enormously important for opening up markets and injecting competition and disrupting existing incumbents. And so we want to make sure that the possibility and opportunity that comes traditionally with these technological inflection points is preserved and not being co-opted to instead allow dominant firms to maintain their monopolies, to deepen their moats. We also in DC hear arguments about national champions, about how it's in America's interest to instead be protecting these monopolies rather than injecting competition. And I think we've all seen, especially recently with Boeing, how those types of arguments can be quite dangerous. So we're really taking a close look to understand what is the significance of these relationships and partnerships, and how do we make sure they're not foreclosing fair competition.
But what prompted you to do that? Was there a tip-off that there was some sort of relationship that seemed anti-competitive to you in the cloud computing space? What was the thing that prompted you to say this needs an investigation? Or it's just your hunch?
So look, as a general matter, there's a lot of opacity here, right? There have been a whole series of news reports suggesting there might be certain strings attached, or firms that are making these investments might be expecting a certain amount of spend on cloud computing. And so we just want to look under the hood, understand what's happening, to make sure that, this is an important moment. And historically, we've seen that when you have new technologies, that's when incumbents can panic. And so we just want to make sure that these relationships and partnerships are not being misused to undermine competition.
The
F.T.C. also did an inquiry into cloud computing over the last year, and so that also brought to the surface just the importance of cloud as an input. So across AI, we're looking layer by layer at each stack, chips, compute, the foundation models, the applications, understanding, who are the major players, are there any bottlenecks or choke points that are emerging, what is the source of that, and how do we make sure it's not being abused?
Well, while you mentioned chips, it just broke that Sam Altman is eyeing a $7 billion investment for chips. Do you have any concerns about him and his role in OpenAI getting involved with chips?
Look, as a general matter, when you have shortages and the need for more production, it's good for additional entities to be getting in the mix there. Of course, when you have vertical integration, so players that are already dominant in a particular layer, and they're then integrating and expanding in another layer where there is going to be a deep relationship, historically, that's something that antitrust enforcers have wanted to scrutinize just to make sure that it's not being misused, that there is not preferencing or discrimination that's distorting competition. So, those are just general principles that we would apply across the board.
I want to get to those principles, but quickly before we move on from the AI investigation, the companies have 45 days to respond. Have you gotten any responses from the firms you're probing yet?
Our teams are in touch with them. We wanted to make sure that we could act quickly, we could get information quickly. Sometimes these market studies can go on for years and years, and the issues here are just so fast moving, so urgent for policymakers to be getting a handle on, that we wanted to make sure we could act swiftly.
You mentioned in your last response that traditionally antitrust regulators have focused on vertical integrations, but your FTC was eyeing potentially suing to block Amazon and MGM, which, there's a lot of competition in this space. Do you think that this FTC is more interested in horizontal mergers, particularly in the media space, than previous FTCs?
So we're looking across the board, with mergers and acquisitions, it's really whatever comes in through the door. And we have a few key principles. One is just making sure that we're focused on the most high impact areas where if there's significant harm that's affecting an enormous amount of people, that's something that as public enforcers, we have an obligation to be addressing. We've been very focused, for example, in healthcare markets. Whether people can afford their medicine can have life or death consequences. And so across the board, we're scrutinizing healthcare. In technology, I think DC as a whole is reeling from the level of inaction that we saw during Web 2.0. There are a whole set of lawsuits, including by the F.T.C, that are now looking to address some of the acquisitions that were allowed by dominant tech firms. We've seen business models around behavioral advertising and tracking of people that have now been baked in, and there's a broader conversation in DC about, how do we address the harms? And so across the board, we just want to make sure we're being vigilant, we're learning from those missteps. We don't focus as much on horizontal versus vertical versus how do we formally define these relationships. We're really focused on the substance rather than formalities.
But then on the substance point, again, let's go back to Amazon MGM. Why was that something that your FTC, I know obviously the commission was not unanimous in pursuing to sue to block it. Why was that something that you were interested in? You thought something like that was harmful enough that it would need a probe? There's so much streaming competition.
Yeah, look, we're not able to talk in depth about non-public information. I'll just say as a general matter, we've seen across the board how in these platform markets, there can be different ways that dominant players are expanding into particular markets and then using those markets to further solidify their primary monopolies or give them a leg up in some of these adjacent markets in ways that can distort competition there. So, we just need to be realistic and look at the facts and understand what's really going on rather than, apply some of these theoretical models that have really led us to miss what's going on.
And would you ever revisit that particular merger? I ask because it sets the precedent for any other future M&A.
Look, every merger is reviewed on the specific facts. And so be it in that context or any future deal that comes in the door, we'd be looking to understand, is this a merger that may substantially lessen competition or tend to create a monopoly? Previous action or inaction doesn't preclude future action.
Yep. What about this streaming service that Warner Brothers, Discovery, Fox, and ESPN are coming together to create in a joint venture? Do you have any antitrust or competition concerns with that?
Look, we share jurisdiction with the Justice Department, and some of these areas are traditionally in their wheelhouse. Again, when these deals come in the door, we look at them very closely. I think stepping back, we're very aware about how journalism and media really faces an existential moment right now. I got my start in some of this work as a reporter, and so the existential crisis that we see independent free press facing right now is a major problem. And historically, we've seen how it was really important for policymakers to play an active role in structuring markets to make sure that an independent free press was viable. And I worry sometimes that there can be a sense of, technological determinism, the idea that the situation that the free press is facing right now was some type of inevitability. But I think looking back, we see how it was the result of policy choices, right? We just heard the prior panel talk about how there's an enormous dependence on a handful of companies for dissemination, for distribution. Those same companies now control and capture a huge share of digital ad dollars. Some of these dependencies and these market power instances were just not an inevitability. They were a function of policy choices. And so those are the lessons that we're now heeding as we look at some of these new partnerships and deals, as well as some of our conduct lawsuits.
So on policy choices, are you going to look at that streaming merger?
Look, as these things come through the door, we talk with the Justice Department. Oftentimes, whether these deals are being reviewed is non-public unless the companies reveal it. So we'll see how it pans out.
And then also on policy changes, you have a bunch of legacy entertainment companies that are hemorrhaging right now. I mean, the TV ad market is brutal. And so they're having conversations about merging, but there's an F.C.C law that precludes two broadcasters from coming together. The prior F.C.C increased market caps so that some of these legacy TV broadcasters and newspapers could come together at the local level. Do you think your F.T.C would have major opposition to two entertainment companies coming together that both own broadcast arms, given how stifled legacy media is today?
Look, it's hard to weigh in on some of these hypotheticals. And as you noted, the F.C.C plays a major role here, and oftentimes their policies end up being dispositive. Historically, the rules that they've had in place to ensure competition and to guard against concentration of power across media markets has been incredibly important. Of course, when companies make, flailing firm arguments to us about how they need to merge to avoid going out of business, we scrutinize that very closely. There's a legal standard that those companies have to make in order to fully benefit from those types of arguments. I think we also need to be, wary of. Sometimes you see a bit of an arms race where companies will consolidate, and then other companies will come and say to us, well, you allowed those folks to merge, and so now you have to let us merge in order for us to be able to compete. And you basically just see, a race to the top in terms of who can become a monopoly fastest. That's exactly what our antitrust laws were designed to prevent. They were designed to prevent concentration in the incipiency. They were designed to be able to check concentrations of power and monopoly power before it became fully fledged. And so as enforcers, we carry the responsibility to be able to intervene and stop before you just see it become too late.
You mentioned the overlap with the F.C.C. There's been a lot of criticism about the overlap between the DOJ and the F.T.C. in doing some of this antitrust work. Your philosophy is that there is room for both of them to take this on. Macon Delormean, we had Jonathan Kantar on yesterday. Macon Delormean, his predecessor, has sort of opposed that viewpoint and said more of that jurisdiction belongs to the DOJ. Why do you argue that the F.T.C. should be taking on competition investigations when you have so much to deal with in terms of consumer deception, spam, all of that?
So look, at the F.T.C., we follow the instructions Congress gave us. Congress created the F.T.C. in 1914 and instructed it to prohibit unfair methods of competition. Those are the words in our statute. And so I don't see it, as my role to second guess the wisdom of Congress. Our job as a federal agency is to follow the job that Congress gave us. And competition is a key part of that, in addition to consumer protection, which actually came several decades later. Congress designed the F.T.C. to have complementary authorities to the antitrust division. There's certainly areas where we overlap, statutes that we both enforce, but the Justice Department, for example, has criminal authority, which the FTC doesn't have. The FTC has something known as Section 5 authority, which means we can go after certain types of anti-competitive tactics that are not prohibited by the other antitrust laws. We have the ability to do things like market studies, which the agency has a long history of doing. And these market studies have historically informed major legislation, major policy, including the Public Utility Holding Company Act of the 1930s, which led to the entire restructuring of that industry. So, we really play complementary roles. I think in digital markets in particular, we see how competition and consumer protection issues really overlap and intersect, right? And so oftentimes firms will be looking to chase growth and scale in the early years. And as part of that, they can sometimes play fast and loose with people's data. And so the FTC has seen how firms that have been able to vacuum up people's data and build up monopoly power have then later in turn be able to use that monopoly power to further engage in consumer protection violations, really with few consequences, because by that point, it's hard for users to really vote with their feet and they don't face enough competition in the market. And so especially in areas where we see consumer protection issues and competition issues be so closely interconnected, the FTC can also have a critical role to play there.
You talked about digital markets, and I do want to get to Meta and some of the big digital players. But first, while we are in a room of digital publishers, last year or a few years ago, the DOJ was probing a very small merger between two major entertainment companies under the F.T.C brand. And that sort of got all of our spidey senses awakened that regulators might have issue with very small scale M&A in digital publishing. Is that something that your agency is focused on or thinking about if we were to have digital publishers come together more?
It's hard to weigh in the abstract. There's no kind of, dollar threshold below which deals are presumptively legal. We look at everything on a case-by-case basis. It's not like there's a $50 million and below exemption to the antitrust laws. As a general matter, the FTC does focus on some of the bigger deals because historically we've seen those bigger deals are the ones that pose the greatest threat to competition. That said, we've also seen historically how some of the smaller deals that can fly under the radar can be part of a broader roll-up strategy that we also need to be attentive to. So for example, last September, the FTC sued this private equity company that had rolled up all sorts of anesthesiology providers in Texas. They bought out the biggest anesthesiology providers, and each of these acquisitions was pretty small on a standalone basis, didn't necessarily seem problematic. But if you zoom out in the aggregate, they had basically rolled up the market and then used that monopoly power to jack up prices so that Texas businesses and residents were overpaying for essential anesthesia services. And so those types of roll-ups, especially when they're conducted by private equity, historically we've seen have sometimes flown under the radar. And so that's an area where we're course correcting as well.
Thank you. Last media question before we move on to tech. Dish and DirecTV, are they small enough now that you think the FTC would be okay with those two entities coming together?
This is, again, an area where DOJ has historically played more of a leading role. And, we'd look at anything that comes in the door on a fact-by-fact basis as we make that assessment.
Thank you. So let's talk about the Meta lawsuit. I know you can't comment on ongoing lawsuits and investigations, but I do want to get an understanding from you. You sued the Meta on privacy. They've countersued you. Where do you think the FTC has a strongest case in this privacy battle with Meta?
Yeah, as you noted, that litigation is ongoing. I'll say as a general principle across our privacy work, which is now also informing our AI work, business models matter, right? And the business incentives created by those business models matter. And so historically, we've seen that if you have firms that are monetizing user data and have a lot of incentive to therefore collect as much user data as possible, remedies or injunctions or consent decrees from the government that are not addressing that core business incentive means that you'll sometimes just have a repeat of the problem. And so we've seen historically firms can treat fines, even fines that sound really large, millions of dollars, even billions of dollars, they can sometimes treat those fines as a cost of doing business if the underlying illegal tactics that they're engaging in are valuable enough to them, right? And so across our work, especially in privacy and now in AI, we're scrutinizing the business model, looking at what are the business incentives created by those business models, and how do we make sure that if we find illegal behavior and therefore need some type of remedy, that remedy is addressing those underlying incentives rather than turning a blind eye to them.
But you only charge $5 billion. I mean, Meta is making well over $100 billion annually in revenue. So wouldn't you argue that your own enforcement mechanism was not strong enough?
So that fine and that consent decree was finalized in 2019 before I arrived at the agency. It was also accepted on a 3-2 vote, so that there were 2 commissioners that strongly dissented from that. And so even at that time, there were differences of opinion about whether a fine alone was enough without addressing some of the underlying business practices.
And would those addresses include potentially breaking up Meta's business, charging it more? What do you think is the effective strategy so that they don't just use this as a cost of doing business?
So the F.T.C. moved to modify the consent order that they entered in 2019. And one of the provisions that we seek to modify would actually address Facebook's ability to monetize kids' data. And so that's one of the provisions that we've put forward that, as you noted, is now being litigated over in court.
Yep, let's talk about what's going to happen in the future. Obviously, you've come in with the Biden administration. What do you think happens to your agency, and what do you do if we have a Trump presidency next year?
Look, I have the great honor of serving under President Biden. We obviously don't know what's going to happen in November, but I think as a general matter, one of the most fascinating aspects of the anti-monopoly work is that there is strong bipartisan concern here. I've had the chance to testify in Congress a few times and have been really struck by how members on both sides of the aisle are really concerned. They're concerned about big tech monopolies. They're concerned about how monopolies in areas like our healthcare system or our food system are hollowing out parts of rural America, making it difficult for Americans to be able to afford groceries or basic medical services. And so those are the concerns that I have that give me faith that no matter who wins in November, the commitment to strong, robust anti-monopoly work will last beyond my time at the agency. I'll say as a general matter as well, the issues that we see in media markets and the threat that major monopolies are posing to these media markets, I think is also going to continue to be relevant because we've seen how existential that is, not just for the free press, but also ultimately for our democracy.
And my last question before we let you go, Lina, you have argued that even if you lose a lawsuit, it is effective in that it scares companies off from trying to potentially engage in more anti-competitive mergers. Do you have any proof that that actually does scare them off?
Look, we only bring lawsuits when we think we can win. We like to win. Historically, we've seen that, lawsuits, including the one that the Justice Department filed in the late 90s against Microsoft, can have an incredibly important deterrence effect, both with the company that itself was charged, but also more broadly in the market if you're providing clarity about what types of business practices are illegal. We have to remember that these underlying antitrust laws go back over a century. The Sherman Act was passed in 1890. The F.T.C. Act and Clayton Act were passed in 1914. And we're charged as enforcers with applying these across the economy. And so sometimes there can be open questions in the public, in the business community, about how some of these principles apply in newer markets, in digital markets. And by bringing lawsuits and by explaining to the public which practices we view as violating the antitrust laws can provide a broader public service, including deterrence.
That's helpful in that Microsoft was the example you provided in that question. Lina, just a few things that we've learned today from you as we wrap. The expectation of exclusivity, especially as it pertains to things like cloud computing contracts, is what we're learning, seeking to learn in those investigations into AI companies. When I asked you about going after smaller media M&A, you said the one thing to consider with a case like Amazon and MGM would be that platforms can often further solidify someone's market dominance, which is why you would need to look into that. I thought it was very interesting that you said, as it pertains to everything going on with Meta, that you guys have moved very sort of quickly to address some of these things as these companies get bigger. There's strong bipartisan concern about what's happening in competition law, so you believe that there will be an FTC that is strong under the Trump administration. You would not let me know if you would do any sort of pushback on the big streaming mergers that is yet to come. It is probably too ahead of our time right now to be talking about that. But we do appreciate your time. Thank you so much, and we hope to speak to you soon.
Thanks so much.
All right, over to you.